Okay, so this is Family Quiz 2, and I'm not going to go over the straightforward, easy questions. So number 2 says, for the purpose of child support, which, if any, of the following are included in the term income, as that term is used when calculating child support? Now, basically, the way that you're going to answer this question to be successful is you have to memorize the list of what is deducted. And then you don't have to worry about what is included because you'll know no matter what they throw in there. For example, fellowship income, I don't even know what that is, but I know that it's got to be included because it's a matter of knowing what is deducted and then everything else is included. Just to make this totally clear, the way that this reads in the statute, it's in subdivision 5, and it says income shall mean, but shall not be limited to, the sum of the amounts determined by the application of clauses, these are Roman numerals 1, 2, 3, 4, 5, and 6, reduced by the amount determined by the application of clause 7. This does not say anything about prior tax returns. It says gross total income as should have been or should be reported in the most recent federal tax return. If an individual files jointly, such person shall be required to prepare a form sworn to under penalty of law disclosing his or her gross income individually. Little 2. To the extent not already included in 1, investment income reduced by sums expended in connection with such investment. Okay, now 3. This stuff might seem a little tricky, but it basically says that to the extent not already included in gross income, the amount of income or compensation voluntarily deferred and income received, if any, from the following sources. Then it has this list about workers' compensation, disability, unemployment, all that stuff, annuity payments, and now subdivision 4. This is where it begins to discuss imputed income, non-income producing assets. Okay, if you own lots of jewelry or something. Things that are given to you as part of your job that basically reduces your own expenditures. So if you have a business or you work for a company that gives you a vehicle or gives you a cell phone, and you don't have to pay for that stuff on your own, and a regular person would, that stuff is imputed income or can be imputed income. Money, goods, or services provided by relatives and friends. Roman numeral 5. Now, this is where you can get confused because you may be seeing it done in your courthouse. It says an amount imputed as income based upon former income if the court determines that the parent has reduced resources or income in order to avoid obligation for child support. But if they want to look back the 3 years, they can, but they can only do that and apply it as income if the court determines that the parent has reduced resources or income in order to reduce or avoid the obligation. Now, Roman numeral 6. To the extent not already included in gross income, the following self-employment deductions carried on by the taxpayer. And then it has another list here. So basically all of this stuff is just stuff that you can read, but you do not have to memorize it. Now, when you get to subdivision 7, this is what you have to memorize because this is the list of 9 that I'm either went over or going to go over. Okay, so then there's a list of 9. Now, when you get down to subdivision E, says where a parent is or may be entitled to receive non-recurring payments from extraordinary sources, not otherwise considered as income, including but not limited to, and then we have a list of 5. Okay? Life insurance, 2, discharges of indebtedness, 3, recovery of bad debts, 4, gifts and inheritances, and 5, lottery winnings. But all that stuff would have to be determined by the court, but it's still not automatically deducted. So while this list is important to kind of just read and maybe be able to recognize, It's not the list that's absolutely crucial. If you're going to memorize one of the lists, make it that list of 9. Now this is in subdivision F. The court shall calculate the basic child support obligation and the non-custodial pro rata share. And if it's unjust or inappropriate, the court can make a finding based on one of these. Let's see how many there are. There's 10 items. So the one that I think is kind of noteworthy is that a determination of the gross income of one parent is substantially less than the other parent's gross income. So that would be if one parent, the non-custodial parent, makes $30,000 a year and the custodial parent makes $2 million a year. Well, maybe then the 17%, which is basically going to turn the person making 30 grand into a totally destitute parent, maybe that's not the best idea. It's in here to give the court a little bit of discretion when there's extraordinary circumstances. In both subdivision E and F are talking about extraordinary circumstances like relocation, drastic difference in the income, something like that. In subdivision 9, it says, provided that the child is not on public assistance, extraordinary expenses incurred by the non-custodial parent in exercising visitation or expenses incurred by the non-custodial parent in extended visitation, provided that the custodial parent's expenses are substantially reduced as a result thereof. So an example of this would be relocation permitted. And the court now is aware that the non-custodial parent is going to be spending a lot of money to visit the child, either on flights or hotel rooms, rent a car, meals out because you're not able to really cook if you're staying in a hotel, and the fact that usually when there's a relocation, there's an extended period of visitation over the summer or during school breaks. Why would it make sense for them to be still receiving this child support when the non-custodial parent is essentially supporting the child and then on top of that paying the custodial parent's support? So that's why this is in here. Okay, so now I'm going to give the list of what is deducted prior to the calculation. The first one is unreimbursed employee business expenses, except to the extent they reduce personal expenditures. Alimony or maintenance actually paid to a spouse not a party to the instant action pursuant to court order or validly executed agreement. Alimony or maintenance actually paid or to be paid to a spouse who is a party to the instant action. Child support actually paid pursuant to court order or written agreement on behalf of any child for whom the parent has a legal duty of support and who is not a subject to the instant action. Or public assistance, 5 SSI, New York City, income or earning taxes actually paid, and Yonkers taxes actually paid, FICA taxes actually paid, that is the Federal Insurance Contribution Act. The list is a total of 9 items. Quickly again, unreimbursed employee business expenses. 2, alimony or maintenance paid to a spouse not a party. 3, alimony or maintenance paid to a spouse who is a party. 4, child support paid to another kid. 5, public assistance. 6, SSI. 7, New York City income tax actually paid. 8, Yonkers tax actually paid. And 9, FICA taxes actually paid. Literally everything else, if it's not one of those 9, is part of child support. So now with all that said, I'm going to go back to question 2 and read it. For the purpose of child support, which, if any of the following are included in the term income, as that term is used when determining child support. And now I'm going to know in my head, I know the list of 9, and I'm going to look to see if any of them are on here. The only one that's on here is in choice 3, SSI. That means these other ones, they are included. So the answer is D, 1, 2, 4, and 5, but not 3. Okay, number 3. Self-support reserve means 135% of the poverty income guidelines for a single person. So the poverty income guidelines is the federal one, and the self-support reserve is the New York thing. 4. When a non-custodial parent's income is less than or equal to the poverty income guidelines for a single person, unpaid child support arrears in excess of $500 shall not accrue. So this question is specifically talking about the poverty income guidelines. So it's the federal standard. Okay. Number 5. Now, here's the easier version of the question in number 2, because it's just basically knowing, again, the list of 9 and looking for the items. So 1 is SSI. Yep, that's on there. 2, FICA actually paid. Yes. 3, child support actually paid pursuant to court order or written agreement on behalf of any child for whom the parent has a legal duty of support and who is not subject to the inaction. Yes. Or public assistance. Yes. And then New York City income tax, it should say actually paid. Okay. But it's good enough. So I'm going to go A, all of the above. Okay. So question 6. This is about when a child's receiving public assistance or support services, and a party to that order may request the support collection unit review the order for a cost of living adjustment when, and the only 2 choices that are correct on here are the order was issued prior to September 15th, 1989, which I think all those kids are aged out by far now, and since the order was entered, the sum of the annual changes to the Consumer Price Index for urban consumers, the CPIU, is 10% or greater. So as long as it's 10%, they can request a cost of living adjustment. So B, 1 and 3 only. Now, number 7, an objection to a cost of living adjustment must be made to the family court. Did have an issue with question 7. I feel that choice 5 is not really correct because it's not receipt of the order, it's from the mailing. So it's 35 days from the mailing. C and D had the same exact choice and said and one said or. Either way, I think the answer should have been 2 and 4 only. Number 11, 422. Whom, if any of the following, may originate a support proceeding? Now, there is a long list here, and this 7, I believe, does cover it. So it's a husband, wife, child, relative in need of public assistance, social services official, commissioner of mental health, and the parent or guardian of a child or another person who's in loco parentis. So if the child is living with someone who's not a parent, that person can request that the parent pay support. 12, FCA 427. So for support and paternity, so Articles 4 and 5, the summons has to be served 8 days before the appearance. So number 16, support order of the family court terminates unless the Supreme Court, as part of its judgment of divorce, annulment, or separation, continues the order of the family court. Number 17, 516-A. There's so many questions that can be made out of an acknowledgement of paternity. But for the purpose of this one, it's 1, it must be in writing, and 3, filed with the register of the district in which the birth occurred. So the answer is C. The next one is number 18, 524. Now, the reason that number 1 is wrong is because the way the statute reads is that the respondent's failure to appear shall result in the default entry of an order of affiliation. Shall result in the default entry of an order of affiliation upon proof of respondent's actual notice of the commencement of the proceeding. So the reason it's wrong is because it says may and it's not may. It's a shall. The failure to appear shall result in the default entry of an order of affiliation, which if there's an order of affiliation entered by default, you have 1 year from the default to try to vacate it. Now, the other 2, they're correct because it does say may for those 2, for the suspensions. Number 20. Number 20 is false, and the reason number 20 is false is because it's not just a county outside of the county where the case is pending. It's that county plus any adjoining county. So if you live in Nassau County and the case is pending in Westchester, then you can testify electronically. But if the case is pending in Queens or Manhattan, you can't because it's any adjoining county, and the counties of New York City are considered one county for this purpose. So you can't say, oh, well, Queens is the adjoining county to me. Why should I have to go to Manhattan? No, you have to go to Manhattan because New York City's 5 counties are deemed one county for the purpose of this section. 22. If an applicant for or recipient of, now they're calling it family assistance here, but bottom line, it's public assistance, like welfare, is pregnant, and a proceeding to establish paternity has been filed, and the allegation of paternity is denied, there is a stay of all paternity proceedings until 60 days after the birth. 23, 517. Which, if any, of the following are true when proceedings to establish the paternity of a child may be instituted? So 1, well, the last question just gave it away. It's during the pregnancy of the mother. 2 is wrong because the age is wrong. It's when the child reaches the age of 21. So from the ages of 0 to 20, you can establish paternity, and that coincides with the fact that you can get child support up to the age of 21. So from 0 to 20, you can get child support. But it's at any time if the paternity has been acknowledged by the father in writing or by furnishing support. So basically, if I was going to make this question a study question and make it correct, I would do it like this. Proceedings to establish paternity may be instituted, 1, during the pregnancy, 2, after the birth, but except in certain circumstances, not after the child reaches the age of 21, and 3, at any time if paternity has been acknowledged by the father, either in writing or by furnishing support. But for the purpose of this question, the answer to number 23, you should have gotten D, 1 and 3, but not 2. Okay, so now number 24. This actually I got wrong myself on the practice test. 522. Who may not institute a paternity proceeding? And this is a matter of knowing the list and memorizing the list of who may institute it, and then no matter what they throw in there, you will know who cannot institute it.
522. Persons who may originate proceedings. Proceedings to establish the paternity of the child and to compel support under this article may be commenced by the mother, whether a minor or not, by a person alleging to be the father, whether a minor or not, by the child or child's guardian or other person standing in a parental relation or being the next of kin of the child, or by any authorized representative of an incorporated society doing charitable or philanthropic work, or if the mother or child is or is likely to become a public charge on a county, city or town, by a public welfare official of the county, city or town where the mother resides or the child is found, if a proceeding is originated by a public welfare official and thereafter withdrawn or dismissed without consideration on the merits, such withdrawal or dismissal shall be without prejudice to other persons.
So now, after reviewing that list, you know the answer is D, none of the above, because all of those people can commence a paternity proceeding. Be so careful with this because this question was asking who cannot do it. So again, like when I did this practice test, I was looking for who may not do it. The answer that I got was C, which was incorrect, because I did not remember the next kin of the child, because it sounds so ridiculous, but it's on there. Okay, number 25. 25, confirmation of a registered order, whether by operation of law or after notice and hearing, precludes further contest of the order with respect to any matter that could have been asserted at the time of registration. So basically, once the order is confirmed, which happens by operation of law, if there's no timely objection filed, and you have 20 days to object to it. If you do not do that, then that's confirmation by operation of law, and the other way would be notice and hearing. Either way, that's it. Number 26. Which, if any, of the following are true regarding the procedure to register a child support order of another state for modification? So there's a word missing in this question. It should say another state for the purpose of modification or for modification. So I thought that the answer should have been 2, 3, and 4. So I didn't actually get the question wrong, but I still didn't know. So, of course, by process of elimination, I knew 2 and 3 were correct, so I knew the answer was B, but had an option on there for 2, 3, and 4, I would have gotten the question wrong. So the reason that number 4 is wrong is because I think that basically the jurisdictional issue is so convoluted in a way that they want people to be able to do this without an attorney. And if you were asking them to specify the basis of the court's jurisdiction, then it really wouldn't be practicable for a non-represented party to file an appropriate pleading. So that's why all it says in the statute, because I just checked, is that a petition may be filed at the time as a request for registration or later, and that the pleadings must specify the grounds for modification. Now, this is talking about a procedure to register a child support order for modification.
580-609. Procedure to register child support order of another state for modification. A party or support enforcement agency seeking to modify and enforce a child support order issued in another state shall register that order in this state in the same manner provided in sections 580-601 through 580. 608 of this part. If the order has not been registered, a petition for modification may be filed at the same time as a request for registration, or later. The pleading must specify the grounds for modification.
In 602, it's talking about registration for enforcement. So let's do that one.
580-602. Procedure to register order for enforcement, except as otherwise provided in section 580-706 of this article. A support order or income withholding order of another state or a foreign support order may be registered in this state by sending the following records to the appropriate tribunal in this state. 1. A letter of transmittal to the tribunal requesting registration and enforcement. 2. 2 copies, including 1 certified copy, of the order to be registered, including any modification of the order. 3. A sworn statement by the person requesting registration or a certified statement by the custodian of the records showing the amount of any arrearage. 4. The name of the obligor and, if known, I. The obligor's address and social security number. II. The name and address of the obligor's employer and any other source of income of the obligor. And, III. A description and the location of property of the obligor in this state not exempt from execution. And, 5. Except as otherwise provided in section 580-312 of this article, the name and address of the obligee and, if applicable, the person to whom support payments are to be remitted. B. On receipt of a request for registration, the registering tribunal shall cause the order to be filed as an order of a tribunal of another state or a foreign support order, together with 1 copy of the documents and information, regardless of their form. C. A petition or comparable pleading seeking a remedy that must be affirmatively sought under other law of this state may be filed at the same time as the request for registration or later. The pleading must specify the grounds for the remedy sought. D. If 2 or more orders are in effect, the person requesting registration shall 1. Furnish to the tribunal a copy of every support order asserted to be in effect in addition to the documents specified in this section. 2. Specify the order alleged to be the controlling order, if any, and 3. Specify the amount of consolidated arrears, if any. E. A request for a determination of which is the controlling order may be filed separately or with a request for registration and enforcement or for registration and modification. The person requesting registration shall give notice of the request to each party whose rights may be affected by the determination.
Okay, so again, going back to the other one, which was in compared to what we just did.
Choice of law, except as otherwise provided in subdivision D of this section, the law of the issuing state or foreign country governs 1. The nature, extent, amount and duration of current payments under a registered support order. 2. The computation and payment of arrearages and accrual of interest on the arrearages under the support order. And 3. The existence and satisfaction of other obligations under the support order. B. In a proceeding for arrears under a registered support order, the statute of limitation of this state or of the issuing state or foreign country, whichever is longer, applies. C. A responding tribunal of this state shall apply the procedures and remedies of this state to enforce current support and collect arrears and interest due on a support order of another state or a foreign country registered in this state. D. After a tribunal of this state or another state determines which is the controlling order and issues an order consolidating arrears, if any, a tribunal of this state shall prospectively apply the law of the state or foreign country issuing the controlling order, including its law on interest on arrears, on current and future support, and on consolidated arrears.
So now with that, going back to question 26, which, if any, of the following are true regarding the procedure to register a child support order of another state for modification? And the answer is 2 and 3 only. So a petition may be filed at the same time as a request for registration or later. And 3, the pleadings must specify the grounds for modification. Nothing about jurisdiction there. 27, 525. If an order affiliation is entered by default, the respondent in a paternity proceeding has the right to make a motion for relief from such default within 1 year from the date the order was entered. Next, 565, pursuant to Family Court Act 565, a challenge to a directive by DSS requiring a party to submit to genetic testing may be filed in the family court only. Family court only. Okay. So I'm going to do 31 and 32 back to back without stopping. 580-606, a non-registering party seeking to contest the validity or enforcement of a registered order in this state shall request a hearing within 20 days after notice of registration. 614, within 30 days after issuance of a modified child support order, the party obtaining the modification shall file a certified copy of the order with the issuing tribunal that had continuing exclusive jurisdiction over the earlier order. They also have to file it wherever a copy had been registered. So we're in a state where a copy was registered, they have to do it there too. Okay? And don't look at what I checked off there. I know it's 30 days. I checked off the wrong thing there. Okay. 604. In a proceeding for arrears under UIFSA, the statute of limitations under the laws of New York or of the issuing state, whichever is longer, is the one that's applied. So again, the longer statute of limitation applies. So if New York and Oregon both have orders that they issued and there's a proceeding for arrears, it's whichever statute of limitations is longer. That would apply. Okay, next. This is another 427 question, number 38, and this is a very difficult question because the way 427 is written, and then when you read it in combination with personal service upon a natural person in the CPLR, it's extremely confusing. So the way that the question is written better, in my opinion, is it's in a later question. It's much later on. It's yeah, there it is, number 63. So number 63 is a much better study question to understand 427. Basically, the issue with the way this question is worded is that in the CPLR, substituted service is not actually defined in the CPLR. So personal service includes suitable age and discretion. That is a form of personal service. So leave in mail service at least 8 days before the time for appearance, well, not sure if leave in mail service is the same as mail in mail service, because leaving it with a person of suitable age and discretion is completely different than substituted service, which would be by court order. You don't need a court order for suitable age and discretion. So this section is really, really difficult. That's why it's saying in here, study rule 427 very carefully. So I'm going to skip this question, but the bottom line is in the CPLR, in order to do mail and mail, you need due diligence before you can do it. So instead of reading this question the way it is, we're going to go to question 63 and read it the way it's in the statute. So this says personal service of summons and petition in a support proceeding may be made by 1, delivery of a true copy, at least, now that should be 8 days before the time stated in for appearance. So it's like, pretend that says 8. 2, by delivery of a true copy to a person of suitable age and discretion at the actual business, dwelling place, or place of abode of the person to be served, and by mailing a true copy thereof to the person to be served at his last known residence, and again, it's at least 8 days before the time stated in the summons for appearance. If after reasonable effort, personal service is not made, so this is not due diligence, it says reasonable effort, the court may at any stage of the proceeding make an order providing for substitute service in the CPLR. And then 4 says by mail alone to the last known address of the person. And that's true. You can do mail alone service, it's certified mail service in Articles 4 and 5. And they read almost identically. The only difference is in Article 5, it says something about if someone on behalf of the respondent makes an application that the court should not proceed with the hearing for at least 8 days after the summons was served. So that's how it goes in there. It's a really tough question because substituted service is not defined in the CPLR. It's certainly in the Family Court Act distinguishes between substituted service and suitable age and discretion, because right there in the Family Court Act, it says you could deliver to suitable age and discretion and then mail. And then in number 3, it says an order providing for substituted service. So you certainly don't need a court order to do suitable age and discretion, which is why it's really, really, really convoluted. That one. Hopefully we don't get a question on service either in Articles 4 or 5, just because, I mean, I think I know the CPLR service on a natural person pretty well, and I still get confused by it. Okay. So the next one is, that I have here. Okay, number 40. Testimony by audio, telephone, visual, or electronic means may be permitted when 1. The party or witness resides in a county outside the county and that of any contiguous county, and for the purpose of this section, New York City's 5 counties are treated as one county. 2. Party or witness is in jail and not expected to be released within a reasonable period after the date the hearing is scheduled. And 3. Where court determines it would be an undue hardship. And the note here says electronic testimony must be recorded and preserved for transcription. Okay, number 41. A motion to vacate an order of support adjusted pursuant to 413 may be made no later than 45 days after an adjusted support order is executed by the court where no specific objections to the proposed order have been timely received by the court. Such motion shall only be granted upon the determination by the court that personal jurisdiction was not obtained over the moving party. Okay, the court reviewing, this is number 42. The court reviewing a child support order adjusted pursuant to 413-A, so that means support collection unit. Whenever you see 413-A, it's talking about the support collection unit doing the adjustment, shall conduct a hearing and make a determination no later than 45 days from the date it receives an objection. I'm just going to read this because I want to say the words. 43, the fucking chief administrator shall provide in accordance with subdivisions, whatever, 439, for the appointment of a sufficient number of support magistrates to hear and determine support proceedings. Okay, so here, a support magistrate can make all those rulings. Let's keep going. Okay, number 46, a support order or income withholding order of another state may be registered in New York by sending the following documents and information to the appropriate tribunal of the state. This is again for the purpose of enforcement. 1. A letter of transmittal to the tribunal requesting an enforcement and registration. 2. 2 copies, 1 certified, of all orders to be registered, including any modifications. 3. A sworn statement by the party seeking registration or a certified statement by the custodian of the records showing the amount of any arrearages. 4. The name and obligor, and if known, their address, SSN, their employer, any source of income, a description and the location of the property, the obligor, and the seat not exempt from execution. 5. The name and address of the obligee, if applicable, the agency or person to whom the payments are to be remitted. I think number 44 was a nice study question for us, and it was all the above, so that's good. All right, number 47. When a support order or income withholding order issued in another state is registered, the tribunal shall notify the non-registering party. The notice must be accompanied by a copy of the registered order and the documents and relevant information accompanying the order. The notice must inform the non-registering party the following. 1. That a registered order is enforceable as of the date of registration. You must contest the validity within 20 days. Failure to contest precludes further contest of the order. And the amount of any alleged arrearages. Don't forget, upon registration of an income withholding order for enforcement, the registering tribunal shall notify the obligor's employer pursuant to 5241 of the CPLR. Okay, so 47, I just did. Okay, so 48, I don't know the answer to that. I just know that I had to guess on it, so I really don't know what the answer is. Number 48, it says the answer is B. So, yeah, I don't know the answer on that one. I'm going to have to look that up.
2. Available health insurance benefits means any health insurance benefits that are reasonable in cost and that are reasonably accessible to the person on whose behalf the petition is brought. Health insurance benefits that are not reasonable in cost or whose services are not reasonably accessible to such person shall be considered unavailable. 3. When the person on whose behalf the petition is brought is a child in accordance with subdivision E of this section, health insurance benefits shall be considered reasonable in cost if the cost of health insurance benefits does not exceed 5% of the combined parental gross income. The cost of health insurance benefits shall refer to the cost of the premium and deductible attributable to adding the child or children to existing coverage or the difference between such costs for self-only and family coverage. In no instance shall health insurance benefits be considered reasonable in cost if a parent's share of the cost of extending such coverage would reduce the income of that parent below the self-support reserve. Health insurance benefits are reasonably accessible if the child lives within the geographic area covered by the plan or lives within 30 minutes or 30 miles of travel time from the child's residence to the services covered by the health insurance benefits or through benefits provided under a reciprocal agreement. Provided, however, this presumption may be rebutted for good cause shown including the special health needs of the child. The court shall set forth such a finding and the reasons therefor in the order of support.
So, question number 32 has a mistake on it. It should be 1, 2, 4, and 5, but not 3. And I'm going to have Siri explain why.
720. Detention 1. No child to whom the provisions of this article may apply, shall be detained in any prison, jail, lockup, or other place used for adults convicted of crime or under arrest and charged with a crime. 2. The detention of a child in a secure detention facility shall not be directed under any of the provisions of this article. 3. Detention of a person alleged to be or adjudicated as a person in need of supervision shall, except as provided in subdivision 4 of this section, be authorized only in a foster care program certified by the Office of Children and Family Services, or a certified or approved family boarding home, or a non-secure detention facility certified by the office and in accordance with section 739 of this article. The setting of the detention shall take into account the proximity to the community in which the person alleged to be or adjudicated as a person in need of supervision lives with such person's parents or to which such person will be discharged, and b. the existing educational setting of such person and the proximity of such setting to the location of the detention setting. 4. Whenever detention is authorized and ordered pursuant to this article, for a person alleged to be or adjudicated as a person in need of supervision, a family court in a city having a population of 1 million or more shall, notwithstanding any other provision of law, direct detention in a foster care facility established and maintained pursuant to the Social Services Law. In all other respects, the detention of such a person in a foster care facility shall be subject to the identical terms and conditions for detention as are set forth in this article and in section 235 of this Act. 5. The court shall not order or direct.
So now we're going to go to section 235.
Compensation and liability for support and care in counties within the City of New York. Upon the detention, placement or commitment of a child by the family court in a county within the City of New York to a public or private institution other than a shelter maintained and conducted by a society for the prevention of cruelty to children, the Department of Social Services of the City of New York shall investigate the ability of the parent of the child, or other person legally chargeable, to contribute in whole or in part to the expense incurred by the City of New York on account of the maintenance of such child. B. If in the opinion of the Department of Social Services such parent or legal custodian is able to contribute in whole or in part, the Commissioner of Social Services shall thereupon institute a proceeding in the family court to compel such parent or person legally chargeable to contribute such portion of such expense on account of maintenance of such child as shall be proper and just.
So anyway, that is why question 32 is messed up, is because number 3 should have been wrong and the answer should have been 1, 2, 4, and 5, but not 3. And that was not a choice. So if you got that wrong, then You actually got it right. 747. A fact-finding hearing in a PIN shall commence not more than 3 days after the filing of a petition under Article 7 if respondent is in detention. The respondent in a proceeding under FCA Article 7 is in detention. The court may adjourn the fact-find hearing on its own motion for not more than 3 days. True. On the motion of petitioner for not more than 3 days. So that's wrong because it's only petitioner. 3 successive adjournments may be granted under special circumstances. That's true. And 4 is wrong because it's got to be on the record. So the answer here should have been 1 and 3, but not 2 and 4. And number 34, let's see what the answer key said. Number 34, it said D. And that's true. Good. 716. Proceedings under FCA Article 7 are a county where the acts alleged occurred. So the venue in Article 7 is like in criminal. It's where the acts or act occurred. Okay, so 36 is a repeat. So 37, 720 sub 3, detention of a person alleged to be or adjudicated a PINS generally shall be only authorized in 1, a foster care program certified by OCFS. Yep. 2, a certified or approved family boarding home. Yep. 3 is absolutely not because there's no secure facility detention in this article. So no. So the answer was B. 1, 2 only. If a child in custody is brought before a family court judge before an Article 7 is filed, before an Article 7 petition is filed, the court shall hold a hearing for the purpose of making a preliminary determination of whether the child should be, no, nothing to do with detention, it's about jurisdiction. In general, unless respondent waives a determination that probable cause exists, no detention may last more than 3 days. So again, remember, if you're unsure in this Article 7, guess 3 days. Number 40, which of the following are false? At the conclusion of a dispositional hearing on petition for commitment of guardianship and custody of the child, it's 1, dismissing petition, yep. Suspending judgment, yes. Committing guardianship and custody of the child in accordance with 634, that they can't do it after the 18th birthday unless child consents. That's also true. An order of disposition shall be made pursuant to FCA 5 and 631 solely on best interest of child, and there's no reason, and something about, 40. So yeah, so this is, these are all false. I'm sorry, none of them are false, which is why the answer is D. So the only thing that was messed up about this question is that it said FCA 5. I think it just meant to say FCA 631. But anyway, again, this was a false. It was looking for which is false. So if you put A for this, you knew all the answers, you just didn't read the question carefully. So that's not good. So this question I got wrong when I took the test. And it's because I got the suspended judgment portion wrong. So now I know that in FCA Article 6, the maximum duration of an extension is only 1 year. So 2 is wrong. 1 is correct. The rules of court shall determine permissible terms and conditions of a suspended judgment. Yes. The maximum duration of a suspended judgment is 1 year unless the court finds at the conclusion of the period that exceptional circumstances require an extension for an additional period up to 1 year, not 2 years. So 2 is false. The order of suspended judgment must set forth the duration and terms of conditions of the suspended judgment and must contain a date certain for court review not less than 30 days prior to the expiration of the period of suspended judgment. Number 41 says B. So that is true. And number 4, not later than 60 days prior to the expiration of the period of suspended judgment, the petitioner shall file a report with family court and all parties, including the respondent and his attorney or her attorney, the child's attorney, and any interveners regarding the respondent's compliance with the terms of the judgment, suspended judgment. The report shall be reviewed on the court date, and that is true. So ACD can be on court's own motion or any party for a period not to exceed 6 months. That's what this question says. And number 42 is true. Now, I get messed up sometimes who can ask for the ACD on certain ones, but anyway. This one, again, I got wrong because it was about suspended judgment. At the conclusion of the dispositional hearing under FCA 8, the court may order it. The court may. It's either dismiss the petition if the allegations are not established. That's good. The suspended judgment, number 2, is wrong because it's 6 months. Okay. 3 is correct, 1 year probation. 4 is correct, order of protection. 5 is correct, restitution up to 10 grand. So the answer was everything except 2. Okay, because it's a 6-month suspended judgment in that question. And order of protection under 841 shall set forth reasonable conditions of behavior to be observed for a period not in excess of 2 years by petitioner or respondent, or for a period in excess of 5 years upon a finding of the court on the record of aggravating circumstances.